Good afternoon and welcome to a webinar brought to you by AIA Contract Documents. This webinar is titled The Use of ADR in Construction Disputes, What You Need to Know. In this program, we're going to be talking about different forms of alternative dispute resolution. And of course, when I say alternative, I am talking about alternatives to litigation in court. So we will talk in depth on topics like mediation and arbitration, and we'll certainly spend some time discussing how these items are addressed in the AIA contract documents, which are of course the leading standard form contracts in the design and construction industry. We will also talk about things like dispute avoidance and resolution boards, as well as discussing how disputes are resolved on international projects. We will also discuss some of the common concerns and misconceptions about alternative dispute resolution. And we'll give you some tips for how to make ADR processes work better for you. And lastly, we're going to be doing a few live polls throughout this presentation to see what your experience is with alternative dispute resolution. So pay attention for those because we're going to be relying on your participation on a few occasions throughout this program. So with that, let's get into our presentation. So of course, I've got to start with a few housekeeping items. First, this presentation is protected by US and international copyright laws. Please do not copy this presentation unless you have written permission from the presenters to do so. Also, please know that this presentation is registered with the American Institute of Architects for one continuing education learning unit. If you have properly signed up for this presentation, you should be seeing that learning unit show up in your AIA transcript online within 2 to 3 weeks. If you don't see it by about week 4 from the end of this presentation, please feel free to reach out to us and we'll make sure you get your credit and make sure that it shows up properly on your transcript. And lastly, and I cannot emphasize this enough, nothing that you hear in this presentation should be or is considered legal advice. This presentation is offered for informational purposes only, and if you do have a legal issue about a project or situation that you need guidance on, we recommend that you reach out to a licensed attorney in your jurisdiction who can provide you with legal counsel about the specifics of your particular issue. I'll take a moment here to introduce myself and the presenters for this program. My name is Mike Koger, and I'm going to be your moderator for the program. Currently, I serve as a senior director and counsel with the AIA Contract Documents program, and I've been working with the AIA Contract Documents program in some form for the past 10 years, actually 10 years just this past summer. Before that, I worked in private practice as an attorney where I represented owners and contractors in construction-related disputes. And before that, I actually started my career as an architect and practiced architecture for about 4.5, 5 years before embarking on my legal career. And now I'm going to turn it over to our real presenters, Ken Cobley and Mike Mara. And I don't think I'm out of line in saying that these gentlemen respectively are amongst the most knowledgeable people in the industry about AIA contract documents. And of course, I'm referring to Ken for that, and alternative dispute resolution for construction projects. And of course, I'm referring to Mike Mara for that. So first, I'm going to start with Ken. Ken is the Vice President and Counsel for the AIA Contract Documents program. Ken, would you like to tell us a little bit about yourself and your background?
Sure, thanks, Mike. So as Mike said, I am Vice President and Counsel for the Contract Documents content portion of the AIA Contract Documents program. I've been with the program about 17 years now, and prior to joining the program, I spent about 18 years as a private practice construction litigation attorney. My role as Vice President and Counsel is to oversee the work of several other attorneys on the content team in the creation, review, and revision of the entire AIA Contract Documents library. And part of that work, of course, involves reviewing and, when appropriate, revising and staying up to speed with various provisions in the AIA contract documents that relate to alternative dispute resolution. I should note that in my role, I'm also a member of the NCDRC, National Contract Dispute Resolution Committee, and we'll talk a little bit more about that later. That is a group that is comprised of several representatives from several industry organizations and overseen by the American Arbitration Association. So that's my background. Mike Mary, you want to give us a little bit of your background and history?
Yeah, thank you, Ken, and thank you, Mike, for including me on this webinar. We're certainly, as the AAA, delighted to be here, and I myself am delighted to be here. So I grew up in the construction industry and spent my summers and even part of my college years working on construction sites. And developed a passion for that. I then spent some time in the insurance industry, including selling to the construction industry for a little while. And I joined the AAA a little over 22 years ago, and I'm vice president for our construction division. And in that role, I am responsible for expanding the use of AAA construction dispute resolution services in the Mid-Atlantic and New England states. I also have national responsibility through our National Construction Dispute Resolution Committee that Ken mentioned, and work with my colleagues educating the industry on the use of dispute resolution or alternative dispute resolution.
All right, thank you, Mike and Ken. So Ken, I'm now going to turn it over to you for a few minutes. You are our expert on AIA contracts. So could you give us a little bit of the history of the contract documents program and give us some insights as to how they are developed and updated?
Sure. Thank you, Mike. So the AIA Contract Documents program has been developing standard form documents since 1888. No, that is not a typo. It has been about 135 years. And that program has evolved so that our goal is to, in our documents, to reflect practices in the construction industry. During that time, there's been a substantial volume of interpretive case law. As a matter of fact, we are the only group of standard form contract producers that actually has a volume dedicated to tracking cases that cite to our documents. It's called the AIA Legal Citator, and you can go to that volume and look at the document that you're working with, and you can see if there are any cases that have interpreted various clauses within the document. That just should give you some suggestion of how pervasive the use of the AIA documents is in the construction industry. In 1888, we published one document, the Uniform Contract. Since then, the program has evolved to now over 200 agreements and forms that cut across every major delivery model in the construction industry, and that represent agreements between all of the major stakeholders. So over the years, the program has kept in mind several drafting objectives. Key among them is, as indicated before, to be the industry standard or reflect the industry standard, reflect the best practices in the construction industry. We also strive to create documents that are fair and balanced. And by that, I mean that fairly balance the interests of all the major stakeholders that it will be party to the agreement or anticipated to be part of the construction project. And that's because we want to create agreements, documents, tools, however you want to phrase it, that represent really good starting points for the various project participants to come together and agree on major terms. We recognize that some of those documents will need to be edited and modified, but we believe that by starting with fair and balanced documents that appropriately manage the risk and place it on the parties that are best able to manage it and or insure against it, that we create a really good starting point, and the parties can spend minimal time revising the documents before they get them signed and get started on the project. As I indicated, we strive to have our documents reflect the current industry customs and practices, which is why we do revise them. We revise them normally on a 10-year cycle, but it gives us the opportunity to figure out if things have changed and how they've changed and what needs to be tweaked. And finally, one of the key goals is to express in unambiguous terms the intentions of the parties in plain language. And that's so that the parties will understand what they've agreed to, and also if there are interpreters of the contract, i.e. arbitrators or judges, that the contract language itself is easy to understand, and there's not a struggle to figure out what the parties meant. So how do we get to these documents? Well, it's a circuitous process, and you can see from this slide the various steps. We seek industry comment all during the creation, review, and revision cycles. We also look to legal decisions that may have interpreted our documents or that may have a major impact on a position that's been taken in our document that we may need to revise or reconsider. We investigate the impact of changes in industry practices, court decisions, and so on and so forth. It's a draft and review document. We send them out, we get more feedback, we revise, recirculate, all the way up until we finalize and publish the documents. I would say that in the normal course, it takes anywhere between a year and a half and 3.5 years from start to finish in either the creation of new documents or the review and revision of our documents, particularly some of the flagship documents like the A201 and so forth. So Mike, that's a little bit of the history and some of the review and revision process.
Excellent. Thank you, Ken. And you and I have worked together for 10 years working on AIA Contract Documents. I can tell you that that is a perfect illustration of our process. Good design is not always linear. And our process, we do a lot of, looking back at what we've done and double checking to make sure we get it right. Mike, Mara, I'm going to bring you into the conversation at this point. We're going to end up with a lot of acronyms in this presentation. We've already AIA, ADR, AAA. So can you clarify a few of these right at the outset? I'm going to start with alternative dispute resolution, which we often are just going to be referring to as ADR. What is ADR? What does that mean?
Well, there's ADR, I guess, goes along a continuum. And if you look at the slides here, the first thing I want to note is the further you get up the steps in managing your dispute, the longer it'll take and the more it'll cost. The most obvious alternative to litigation is negotiation. And in most cases, a settled disagreement before external costs are incurred is obviously the best solution. So, and for anyone working in the construction industry, we know there's a lot of negotiating going on every day. All day, every day. But at some point, a dispute can escalate to the point where the parties are unable to resolve it. The next step up the scale on the collaborative side still is a standing neutral, or in this case, it could also be DRBs, which we'll talk about later. And then followed by mediation, which is obviously in the AIA documents. Mediation is your last chance to control your own destiny. So we'll talk more about that. And going to arbitration, you're now in an area that's more adversarial, and your fate will be decided by someone else, or say a panel of three. And then there's litigation and obviously war, which no one wants to be in either. And with those, there's some may say there's never any real winners.
Thanks, Mike. And can you now tell us about the American Arbitration Association, which we're going to refer to often as just AAA? What's their role in the ADR process?
So the AAA and our international division, International Center for Dispute Resolution, have been around for some time. The AIA was formed, or the AAA was formed in 1926. Which happens to be the same year that the Federal Arbitration Act was passed. And that act protects the integrity of arbitration agreements by deeming them valid or revocable and enforceable. The AAA's role is not to act as an arbitrator, but rather we're an administrator of the arbitration and mediation processes, and we utilize a panel of neutrals selected for their expertise in the subject matter of the dispute. For construction, the AAA has close to 1,400 arbitrators and mediators across the country, and through the International Center for Dispute Resolution, or ICDR, around the world. The construction roster is made up of not only experienced lawyers, construction lawyers that is, but also industry professionals such as architects, engineers, project executives, and others.
Excellent. So Ken, can you talk a little bit about the relationship between AIA Contract Documents and AAA?
Sure. Simply put, and as this slide suggests, unless otherwise agreed, most of the AIA documents call for mediation and give the parties the option to select arbitration as part of the dispute resolution processes. And in both instances, the AIA default is that mediation and arbitration would be conducted in accordance with the American Arbitration Association rules that are in effect at the time of contracting. And I'll explain a little more. We'll go into a little more detail a little later about what the provisions, how the provisions call for this, and why I say as a default, unless otherwise agreed. This has a long history. The AIA documents have a long history of calling for arbitration, and there's been a long history between the American Arbitration Association and the AIA contract documents. So, as I said earlier, the AIA published its first uniform contract in 1888. Arbitration was the mandated dispute resolution process in that agreement. So as far back as 1888, the AIA's standard form documents called for arbitration as the preferred dispute resolution mechanism. Mike told you earlier that the American Arbitration Association was founded in 1926. Since 1937, AAA has been an option as the provider for ADR services in the AIA's documents. In 1967, the AAA became the default in the AIA documents, and that ties into the creation of the NCDRC, which Mike and I have both talked about. The NCDRC was started in 1966. It was the work of all of these industry groups coming together, sort of under the overall umbrella and supervision of the American Arbitration Association, to create standardized processes and rules around arbitration. And starting in 1967, the American Arbitration Association was the default go-to provider for ADR services in the AIA's contract documents. Why was that? Well, there were a number of reasons. We've talked about the fact that there was this close collaboration between the AIA, other industry groups, and the American Arbitration Association in the formation and continuance of the NCDRC. As I mentioned, it's still in existence. We meet in person once a year, and there's also virtual meetings and subcommittees that meet coming out of it. The American Arbitration Association is a not-for-profit. It's a public service organization committed to the resolution of disputes through a variety of ADR programs and processes. So it seems to make these things build on each other, and it seems to make sense in terms of the relationship. Mike also talked to you about the diversity of the panel, and over the years we've looked at that as a key reason for continuing with the American Arbitration Association as the default provider. There are other ADR administrators and service providers out there, but you don't necessarily get the diversity of panel members that you do with the American Arbitration Association. For example, one group is exclusively retired judges. Well, there are pros and cons to using retired judges. In some instances, the parties think that that is grand. But in other instances, the parties may be looking for something different. For example, in a situation where the dispute revolves around some highly technical design issue, you may want an arbitrator, either a sole arbitrator or somebody on the panel of three, that's an engineer, not necessarily a retired judge, not necessarily an attorney, but somebody that's going to understand the details of the dispute, or an architect, or somebody else who's in the industry as an industry professional, but not necessarily an attorney or a judge. Other times, you may want attorneys who practice in the construction area and are familiar with the current practices and the way contracts are interpreted and so forth, as either the arbitrator or somebody on the panel. So for all of those reasons, the diversity that you get from the American Arbitration Association's panel has been very compelling, and is one of the reasons why the default has been to AAA.
All right, folks, we are now at our first polling question. And with it, we're going to introduce our first form of ADR, which is mediation. This is a simple yes or no question. Have you ever participated in mediation before? So you should see something on your screen that gives you the option to make a selection, and I believe we should be able to see the results of this in real time. So,
just giving it a few more minutes. See if
Okay.
anyone else wants to vote before I switch it over to the results. All right, looks like we're slowing down, and we'll share those results. So it looks like 62% has not participated in mediation.
Okay. Interesting. So then I assume that everybody else, so what, 38% have, huh?
Yep.
I was expecting a bit more than that. Mediation is somewhat common. I would have thought we'd get a few more folks that have participated in a mediation. Interesting. So Mike, Mara, this next section is for you. Can you tell us about mediation? Describe it a little bit, describe how it works.
Sure. And the statistics also surprised me a little bit, but I guess there's a large group of companies that have had no disputes, so that's not a bad thing. So let's talk a little bit about how mediation works. I'd mentioned earlier that it's a party's last opportunity to control their destiny. So it's a negotiation facilitated sessions, and there's no stake in the outcome for the mediator who is working to facilitate the mediation. So their role is to help improve communication, guide negotiations, and really just get to the parties to a mutually acceptable agreement that they choose. It is voluntary in most cases. The AIA documents includes mediation as a condition precedent. So in that case, you do have to go through the mediation step, and it's a non-binding process. The goal of mediation is to get the parties to reach a settlement that is equally acceptable or maybe equally unacceptable to both sides, to all sides, but it gets you to the finish line. So some of the pros let's talk about the pros and cons. We'll talk about the pros first. There's generally nothing to lose. Mediation is voluntary, so you're not you don't need to be concerned that you may lose in a mediation. It's also private, so there's not a docket or anything that's accessible for anyone. It's a private process. The mediators are bound by a code of ethics. They can't disclose any information regarding the discussions during the mediation. It's certainly the quickest or quicker way to get a dispute resolved, certainly quicker than litigation or arbitration. And it gives people the opportunity to kind of test their theories and kind of a non-confrontational setting. It really comes from the dispute from the client's perspective. Also, parties, as I said earlier, get to retain control of the outcome. I think that's really the biggest pro. And a lot of construction relationships are ongoing, so it's a great way to get a dispute resolved and move on to the next project. Then lastly, it's an opportunity for creative remedies. If you get to arbitration or litigation, someone is going to impose an award on the parties. And for mediation, you can explore other remedies. We've seen cases settle with the promise of future work. We've seen cases settled for an apology. So there's different creative remedies that a good mediator can assist with. So looking at some cons, it's hard to mediate if one or any of the parties are unwilling to cooperate. Both parties have to come to an agreement for it to resolve. So There is the concern that it may not end in a resolution, and you may not save the time and money and actually spend a little money for the mediation that does not necessarily lead to a settlement.
All right. Thank you, Mike. And I'll tell you, just from my private practice as an attorney, I'm sure Ken probably feels the same way. I think mediation is a really important step. I think that oftentimes before you get to that point, you can convince yourself you're 100% right, and mediation is really a good opportunity to get an objective read on your theory of the case and see how it tests against, the opposition. So I
would absolutely agree with that. And oftentimes, mediation is the first opportunity for senior level executives in a company to actually understand the underlying dispute, because until that point, they're often getting one side of the story from, say, a project manager or somebody else whose pride and reputation may be on the line in terms of how this thing has been handled so far. But if you have senior level people come to the mediation with settlement authority, oftentimes they hear things that colors the story a little differently and can move towards a negotiated settlement.
Yeah, my experience in overseeing these is I'm often surprised at cases that settle in mediation. But if you look at statistics, mediations where the parties willingly come to mediation settle close to 90% of the time. To me, that's a shot worth taking.
Absolutely. Oh, wow, I didn't realize it was that high. That's amazing.
Yeah, and in most cases, I think the mediation is a day. So the costs are minimal compared to the cost of litigating or arbitrating. Sometimes you get a more complicated mediation that may be multiple days, but then usually the nature of the claims and the potential downside costs are tenfold what the cost of mediation is.
Absolutely. So this next polling question is going to be kind of interesting because the topic that we're going to introduce next is arbitration. It's kind of that next step up on the ADR spectrum that Mike showed early on in the program. And this is, again, another yes or no question. Have you ever participated in arbitration? My guess, of course, is that this is going to be significantly lower than the results that we got, lower from a yes perspective than the results that we got from the last poll. So Molly, have I filibustered enough? Have folks had a chance to enter in those yes or no? Have you participated in arbitration responses yet?
Yes, I think we have a good majority of those listening. Let's see, I'll pop up the results. It looks like only 28 have and 72 have not, 72%.
Okay, interesting.
Get you back.
So Mike, you are obviously our expert on arbitration. Could you tell us what arbitration is and how it differs from mediation?
Sure, absolutely. Arbitration is a private process as compared to litigation. It certainly has formal rules compared to mediation, but it's a little less formal than litigation. Again, as I mentioned earlier, the resolution is imposed versus negotiated. And it's law and fact-based versus interest and needs-based. Arbitration's also a creature of contract. Parties agree to arbitrate in a contract before a dispute arises. Although parties can also agree to submit their dispute to arbitration by agreement after the fact. We rarely see that. Our experience is that once there's a dispute, parties seldom agree to anything. So once they're in the arbitration process. It's important if you want to take advantage of arbitration versus litigation, that you make sure that you check the box on the AIA documents for arbitration, or otherwise include an arbitration agreement in your contract. The other thing about arbitration is that it's final and binding. It's very difficult to get an arbitration award vacated. You have to prove almost collusion or obvious conflicts of interest. So arbitration is, the benefit of arbitration is that it's final and binding, and I guess some could say a con is that it's final and binding. I guess it depends on which side you land on.
So Mike, I'm going to jump in and ask a question. You said that arbitration is something that you have to agree to in a contract. How should someone go about finding or crafting arbitration language to include in a contract? And what kinds of issues should you be thinking of when reviewing or drafting arbitration language?
Sure. Mike, arbitration is as I said, a creature of contract. So it's the parties' process, and the parties can customize it however they see fit to meet the needs of their particular project. A standard American Arbitration Association clause or the AIA document clause will get you into the process, and it'll be governed by the rules. But a clause can be customized for the particular project. The AAA has a tool for that. It's available at clausebuilder.org, and it's just what it says. It's a clause builder platform. It allows you to start with the generic arbitration clause and then customize it with language that's been developed and tested over the years. So you don't have to reinvent the wheel, but you can, of course, customize the number and qualifications of the arbitrator or panel of arbitrators. You can select your choice of law provisions. You can control costs by putting limits on discovery, and confidentiality is something that we see a lot in the clauses. Although the process is private in that there's no docket, and the AAA and its arbitrators are bound to the privacy of it. It's not necessarily confidential in that any of the parties can post it on social media, contact news channels, whatever they want to do with it, unless there's a confidentiality clause in the actual contract.
Awesome, thanks, Mike. And I actually had a chance to play around with Clause Builder a few months ago, and it is pretty clever. So I'd recommend folks take a look at that if they get a chance. Ken, I'm now going to turn it over to you. I know that the AIA contract documents have plenty of language with regards to mediation and arbitration. Could you walk us through some of the standard language that we've got in our AIA contract documents?
Sure, Mike, thanks. So first, let's deal with mediation. The AIA contract documents, almost all of our agreements provide that the parties must go to mediation as a condition precedent to binding dispute resolution. Now, the parties are free to change that. Obviously, the contracts are editable, but that's the starting position. And I think the three of us talked about what we all perceive as the benefits of trying mediation before expending the substantial costs and energy and human capital associated with binding dispute resolution, whether it's mediation, whether it's arbitration or litigation or some other version. So mediation is a condition precedent. That means that in order to get to binding dispute resolution, whatever it is you selected, arbitration, litigation, you have to go to mediation and you have to at least participate in the process. It doesn't mean you have to come to a resolution, but you have to at least make an effort, a good faith effort, I would say, to mediate the dispute. Um, unless the parties mutually agree otherwise, this is where I talked a little bit about the default. The mediation shall be administered by the American Arbitration Association in accordance with the rules and procedures that are in effect on their rules and procedures that are in effect on the date of the agreement. So as Mike mentioned, both for arbitration and mediation, the American Arbitration Association has a set of rules that the parties agree to be bound by when they go through this process. And so, again, the the AIA documents default to AAA, default to their rules, but the parties are free to agree to other rules or other methods if they so desire. And again, mediation has to proceed in advance of binding dispute resolutions. And then you can see that there are other provisions about the parties sharing the fees of the mediator. The mediation will be held in the place where the project is located. And most importantly, or very importantly, if the parties reach a settlement as part of mediation, they agree that it'll be enforceable as a settlement agreement in a court having jurisdiction over the matter. So the goal is to get the parties to reach an agreement, to enter into an agreement, and therefore settle the dispute. Now, after mediation, if the parties don't settle, then it's arbitration. This is the AIA documents have changed over the years. At points, arbitration was the default. Now, arbitration is one of a few items that you can select for binding dispute resolution. Again, mediation is non-binding. You can go and settle. The settlement agreement will be binding, or you can go and the parties can fail to settle, in which case you then go to either litigation, arbitration, or some other form of binding dispute resolution. And that means somebody, as Mike has said, somebody else is going to decide the outcome of this claim. Again, the default is to the American Arbitration Association in accordance with the rules in effect on the date of the agreement. The arbitration takes place where the project is located, unless the parties agree otherwise. There are limits on when arbitration proceedings can be instituted, and the AIA documents try to tie them in so that you have to institute arbitration proceedings within the same amount of time as you would otherwise have to institute litigation, so that you don't get more time, you don't get less time. There are other rules associated with it. I'll just briefly touch on the fact that the AIA documents allow for the parties to engage in consolidation and joinder. Those are concepts that are also allowed in most courts under the rules of procedure. Consolidation is where one or more cases that have the same core set of facts are consolidated into one proceeding to save resources, conserve on resources. Joinder is where other parties are added to the dispute because you need the other parties to be present to get a full resolution of the conflict. There are more rules around that, but that's sort of the baseline version of it. And then finally, how do you get to arbitration? Well, as I mentioned several times now, there's a checkbox in most AIA documents, and you can see it here. The parties can select arbitration, they can select litigation, they can specify something else. What else is there? Well, there are different machinations of ADR. You can have something called meet-arb, where you start out in mediation, and if the parties can't settle, then the mediator becomes the arbitrator, and they render a final and binding decision. There's baseball arbitration, which is a little different than the standard, where the arbitrator is given a choice of highs and lows, or where they can go in terms of finding a resolution. They have to award within certain limits. There are dispute adjudication boards, which are similar but not identical to something that was mentioned earlier, which is dispute review boards, or and we're going to talk a little bit more about that. In some instances, dispute review boards can have attributes that are very similar to can be binding on the parties. So you can see the checkbox. If nothing's selected, the default is litigation for a few legal reasons, but oftentimes the parties will select arbitration in accordance with the terms that we just looked at.
All right, thank you, Ken. And it is time for another polling question. This one's going to be a little trickier, and it deals with dispute avoidance and resolution boards, something that Ken was just talking about a moment ago. Please respond yes or no. Have you ever participated in a dispute avoidance and resolution board? And for what it's worth, I'm going to put my hand down, because this is the only one of these polling questions that I would not be responding affirmatively to. So I've never been involved in a dispute that made use of a dispute avoidance and resolution board, but please say yes or no whether or not you have in the poll that you should be seeing right now.
I guess, yeah, more generically, it's the DRBs, I think that most people are familiar with, but very interesting results there, Mike.
I'm actually not able to see on my screen. What were the results?
No for 94%.
Oh, wow. Yeah, I'm not entirely surprised by that. I figured that would be a more, I guess, outlier condition for most folks to be involved with one of those. So Mike and Ken, just so you guys know, we're getting I think we're a little bit behind on time, although so we'll probably need to speed up for the next section. But I am going to turn it over to you, Mike. And I want to get your insights on what kind of procedures or guidance that AAA offers with regards to dispute avoidance and resolution boards.
Sure, Mike, and I'll try to be quick on this one. So the AAA just released within the past year a revised DRB process, or dispute resolution board, dispute review boards, as they're also known. We've rebranded the dispute avoidance and resolution boards because of the focus on the real-time resolution on the job site. For the DRB process, the board, and by the way, the board can also be a single neutral that serves on their own rather than 3 DRB members. But as part of the process, there's regular meetings with the stakeholders, and the real benefit of the regular meetings, regular visits on the job site is the ability to nip issues in the bud before they turn into a dispute. If they're not resolved, the disputes are not resolved in real time, there's a more formal process that can be requested, and the parties can elect that hearing process to be an advisory process or a binding process. And if a non-binding process, the recommendations may be designated as admissible in arbitration or litigation, or not admissible, and it is the party's choice at the outset. At the outset of the DARB, there's a 3-party agreement that is signed by all the parties when it is formed, and the decision whether it's binding or non-binding, or admissible or not admissible, is made at that time.
And thank you, Mike. And I mentioned at the outset of this program, we're going to kind of change directions a little bit here. I mentioned at the outset of this program that we're going to be talking about dispute resolution in an international setting. Is there anything that you would do different for dispute resolution in an international setting than you would here in the United States?
Well, I guess for one, we would name the International Center for Dispute Resolution. You would have to make a decision at that time whether you were going to utilize the AAA domestic rules, construction rules, or the international rules that ICDR puts out. I think in that it's important to understand where you are and what the cultural differences are, understanding whether it's common law versus civil law, and knowing if the place of the arbitration is going to be governed by the New York Convention. So there's some things to think about when you're doing work overseas, and the one thing that we do know is that although arbitration is considered an alternative here in the U.S. domestically, not so much so in construction, where I think the majority of cases are arbitrated, but more broadly on the international side, arbitration is almost the default, and largely because nobody wants to be in a foreign court.
Interesting, Mike. I'll tell you, that sounds like that sounds like you've got an hour worth of content right there on the screen. Good topics for another presentation. That would be one that I would want to listen to and not participate in, because I can tell you I've got very little experience in international dispute resolution. So I'll be in attendance at the next one that we do that's on international dispute resolution. Ken, one thing I do know about the AIA Contract Documents program is that we just went through a pretty thorough process to update our international design agreement, which is our B161-2022. Can you talk about how that document deals with dispute resolution and how it differs from our other agreements?
Sure, Mike, but I'd like to get to some of the other content at the end, so I'm going to go fairly quickly through this. So as you mentioned, we have one design-based agreement for use on international projects. For those of you that are reading the screen, you can see the terms client and consultant. Client would be the foreign owner. Consultant would be a U.S.-based design firm for the purposes of that agreement. And you can see that the parties agree to resolve disputes in accordance with the terms under Article 10. Now, just like in all of our other major documents, the international document calls for mediation and arbitration. A lot of similarities, a lot of stuff that Mike already talked about. It's a condition, mediation is a condition preceding to binding dispute resolution. Unless the parties agree otherwise, it's administered by the International Center for Dispute Resolution, the ICDR, which is what Mike talked about, and in accordance with their rules. I think the interesting thing here is part of this is the selection of a major city where the mediation will take place, as opposed to the site of the project. And there's some stated language like the proceedings being confidential and so on and so forth. If the parties don't settle, then they go to arbitration. And there are a number of similarities in the international arbitration terms, similar to what we already talked about for the domestic projects. There are some different timelines that are set up for bringing claims and so on and so forth. But I think you can see largely the terms are very similar. The seat of the arbitration, the place where it's going to occur, is going to be the same place that the party selected for mediation. That's a little different. And then, but the award is final, rendered by the arbitrators is final, and a judgment can be entered. The question is, under what terms, under what agreement in international can the parties enter the judgment? I would say for anybody who's interested in international dispute resolution, I would refer you to the AIA's document B561. 2022, which is a guide to international projects. And there's several page discussion about international mediation and arbitration and the different conventions. So we have material out there. It does exist. And of course, AAA, ICDR are expert in international ADR.
Ken, is there a, so there's not a check box that needs to be checked for international arbitration?
Correct.
Okay.
We defaulted to arbitration, largely, Mike, because of what you said. Our understanding is that that's sort of the game of choice in international.
Well, thanks, guys, and sorry to kind of hurry us through those last few slides, but I want to get to the slides that we're starting right now in this section. Ken, we've talked. I'm going to start with you. We've talked a lot about the benefits with regards to arbitration. Are there any concerns that people have about using arbitration? And in your experience, are those concerns well-founded?
Yeah. So over time, we heard several concerns. I'm sure Mike heard similar concerns, and I know he's going to address them. One of the concerns that people often have about arbitration is they say, well, the arbitrators don't really decide for one party or another. They try to split the baby. Arbitration was originally considered to be a much less expensive dispute resolution procedure, but over time, it's become more complex, and so the parties often argue, well, it's just as costly now as litigation. They complain about the fact that, years ago in arbitration, discovery was very limited. Now they feel like discovery is as out of control and as expensive in arbitration. And finally, if you go to court, in the court system, you're going to have appellate rights. Parties complained about not having appeal rights, and I know that Mike can address all of those.
Well, sure, Ken. If we take a look at the graph here on split the baby, by the way, that's my baby picture. I'm the happy baby, seriously, the perception of the split the baby, I'm not exactly sure where that ever came from. It may have arisen out of the labor area, where the perception there is that one for the employer, one for the union. But on commercial construction arbitration, our experience has not been that the arbitrator split the baby. As you can see on this graph, this is one of many studies that have been done. Only 7% of the cases are awarded in the mid-range of 41 to 60% of their filed claim amount, and 93% were awarded outside of the claim mid-range. So it's really an unfounded perception. It's been kind of debunked by many studies in that regards. As far as cost, Mike, if we can go to the next slide. The arbitration process, as I mentioned earlier, is the party's process, and I agree that I've seen cases that are in arbitration that look like a litigation. There's interrogatories, there's motions, there's multiple depositions. I can tell you that's not the norm, and it's completely controllable by the parties. The arbitrators are trained to try to rein in the process, but again, it's ultimately the parties' process, and if they agree to litigate, to arbitrate it with the litigation rules, it's difficult to control it. What parties can do at the outset, as I mentioned earlier, is customize their arbitration agreement. They can certainly limit numbers of depositions if they allow them at all. They can certainly limit any of the discovery. Electronic discovery is an area that needs parameters. So they can address in their contract document exchange. They can address if there's going to be a site inspection. They can address, as I said, the number of depositions, how they're going to handle any discovery disputes, third-party discovery, how that's handled. So there's things that can be addressed at the outset. Looking at this next slide on discovery costs, if you go to the ADR.org website, you can download a copy of this, and it's really a structure or guidelines for parties and their counsel to follow along with the arbitrators. And lastly, the appellate question is an interesting question. We often would hear that I don't want to use arbitration because there's not an appeal process. It's final and binding. In 2013, we developed appellate rules. And I can tell you that it's been used a handful of times. It has not been used at all on any construction case that we've seen. But it's been used on a handful of commercial cases. So I think that ultimately that parties in arbitration really do want the finality of the process. And back to you, Mike. I think that wraps it up.
Yeah, thank you. Well, first of all, thank you both, Mike and Ken, for taking time to chat with me about these things. And I am going to, if folks in the audience want to just hang on for about 2 more minutes, we're going a little bit over time, but I want to get a last polling question. We want to make sure that we're doing programs that are of interest and value to you and your practice. So our last question is going to be a self-serving one for us so that we can, make sure we know which programs to do in the future. If we were to do another presentation in the future about ADR topics, which of these 3 topics would you prefer? Selection number 1 would be arbitration and particularly customizing the arbitration experience. Selection number 2 would be dispute avoidance and resolution boards, how to use them. And selection number 3 would be understanding international arbitration and dispute resolution.
And Mike, I think they can select multiple, right? It's not a choice of one. You can pick as many as you like, correct?
I think so. Molly, please correct us if we're wrong on that.
That is correct. You can click multiple before you hit send, of course.
Good.
I'm just going to give it a couple more seconds because I keep seeing those numbers move. I want y'all to get as many data points as possible. Okay, I will close it off.
All right, folks. Well, thank you all for listening to this presentation. I want to throw up some contacts and resources for you. At AIA Contract Documents, we have a ton of articles, videos, and guides, and all kinds of other FAQ materials. You can go to our learn.aiacontracts.com page where you can find all of those resources. Also, if you have a question about our AIA Contract Documents from a content perspective, you can contact us at docinfo@aiacontracts.com, or you can call the number on the screen. However, we cannot give legal advice. We can tell you, we can kind of help you pick, kind of pick through our documents and tell you what certain things mean to us, but we can't give you legal advice if you contact our AIA docinfo program. Lastly, if you have questions about our tech support if you use our software every once in a while, it has a bug or something, you can shoot us an email at support@aiacontracts.com if you have a tech support question. And if you want to contact AAA, you can contact Mike Mara directly at marram@adr.org. If you want to purchase AIA contracts, there are a handful of options on our purchase link, which you can see on the screen. We offer documents in a variety of formats. You can either buy documents that are one-time use only, or you can buy documents that have an unlimited use. So you can buy like a yearly subscription. And usually there's a break-even point. You work on a few projects with a handful of contracts every year. You might only need one-time use documents, but eventually, once you get past the 3 or 4 projects with a number of contracts per contract, it might actually start to make sense to do that unlimited use selection there. We thought we were going to have time for questions. We are not. Please go ahead and send us questions via the chat here feature on GoToWebinar. We'll try and respond to those in the next week or so. And thank you everyone for joining us on this webinar.